Hello, my friends. This is Advocate Dr. Prashant Mali, and today we'll talk on a very short presentation on what is the comparison between the Indian DPDPA, that is the Data Protection Act from India, and European Union's GDPR. Because a lot of people uh, are GDPR compliant, but they may not be DPDPA compliant. There are certain resident differences. So we're going to see one by one, at least in the short format. So let's start with it. This presentation is brought to you by Cyber Law Academy, and the content design is being done by Cyber Law Consulting, the law firm. So let's start to look at the applicability of DPDPA. Since this is an India focused presentation, let us see what is the applicability. Now, this DPDPA applies to all personally identifiable data except the data that is made publicly available. So, there is no distinction here. Every personally identifiable data of every person, DPDPA is applicable. Now, just to remember this point, it is only applicable to data which is collected in the digital format or which is afterwards digitized. To give an example, now suppose in a KYC form, you are submitting the KYC form in written mode and you're giving documents attached to KYC as of in photocopy format, then DPDPA is not applicable. DPDPA applicability comes when the moment the insurance company or the bank or any company doing your KYC converts these physical copies into digital format or it does eKYC. I hope the example makes it clear what is the applicability of DPDPA. Now let's come to the GDPR. The GDPR applies to all personal data, whether it is digital or non-digital data. The GDPR also recognizes special categories of data such as sensitive personal data, while in India there is no special category of data called sensitive personal data. It only applies to your personal data. So that point needs to be kept in mind. Now let's go to the next point, that's called grounds for processing of data. So the grounds for processing data in India as respect to DPDPA are the lawful purposes. So if you want to process data, the purpose has to be lawful. You can't have an unlawful purposes like explicitly barred by any law, not only by DPDPA but barred by any law. A notice has to be given in 22 languages which are specified in the second schedule of our Indian Constitution. Consent has to be taken. Now, this consent, my dear friends, it is explicit consent has to be taken, and the data has to be used only and only for legitimate uses. Then, these are the grounds for processing under DPDPA. Now, let's move to the GDPR part here. In contrast, the grounds include consent, contract performance, legal obligation, vital interest of individuals, public interest, and legitimate interest. If you see, the scope here for processing in GDPR is much higher than in DPDPA. Here, vital interest and legitimate interest are grounds for interpretation by your legal people or law firms. So, but DPDPA is very clear on this. So, what are the legitimate uses versus legitimate interest? Now, the term legitimate interest in GDPR in comparison to legitimate uses in DPDPA. Now, see the words used are different. Offers more flexibility for businesses in terms of data processing, while the scope in term legitimate uses is limited to 9 uses only. So interpretation wise GDPR gives you more flexibility. DPDPA is right now constrained. Take it, my friends, that when the rules come and when the case laws start to get happen via data protection board and appeals in the higher courts, I think this scope, this other things mapping to GDPR or to any other good law in our country will slowly become viable. Now, who are the stakeholders which are recognized by DPDPA? Now, DPDPA recognizes data fiduciaries, significant data fiduciaries, data processors, and data principals. So now these four words: fiduciary, data fiduciary, significant data fiduciary, data processors, and data principal. Words differently used in GDPR. We'll see it in the next slide. Now, the DPDPA states that certain classes of data fiduciaries may be classified as significant data fiduciaries. Now, what are these classes? The rules have yet not come. What could be the formula to classify a data fiduciary as significant data fiduciary? The rules are yet not clear, but with my experience, I can tell you it depends upon the amount of data, volume, and sensitivity of the personal data which they are going to process. Risk to rights of data principles, when the risks are high, like example is social media companies where data risk to the data could be high. Even e-commerce companies, even fintech companies, they can get classified under DPDP, or even for that matter, gaming companies who have huge amount of data in their game database and which is personal data. So the also there are other points as what is the impact of data with the data fiduciary which impacts the sovereignty and integrity of data. Then also they can be classified as significant data fiduciary. And the important thing here is if this data is risk to electoral democracy, means the risk to when elections are happening, the data which they have can actually affect the universal suffrage or affect the voting pattern, affect the governments in states, etc., security of the state, and public order. Now, here I want you to emphasize public order is a word which can be widely interpreted. Governments have been doing this before and they will do it ahead. So, government, it just think this as it is on the government's whims and fancies that they can declare any data fiduciary as significant data fiduciary under the public order. Now, when you look at GDPR, the GDPR terms data fiduciary as data controller and data principals as data subject. GDPR also recognizes data processors and data subprocessors. So when you look at GDPR, then you have this three principal terms: controllers, processors, and principals, and a concept of subprocessor. So it is pretty straight there. There is no concept of significant data fiduciary or significant data controller even when it comes to GDPR. Consent is my favorite topic always, and consent for children, specifically, I'm covering here is uh, in DPDPA, the children below the age of 18 requires verifiable parental consent, and additionally behavioral monitoring, targeted advertising, tracking, and any other processing activity that may be detrimental to child's well-being are forbidden by the DPDP. I want to emphasize one fact here. About this, the rules are going to come in data protection rules. They are likely to mention that registering Aadhaar card and using Aadhaar data to authenticate whether the child is below 18 years and who could be his guardian, etc. When it comes to GDPR, on the contrary, the GDPR mandates the children below the age of 13 require parental consent. So age difference is there. Age difference is also kept to various European Union countries depending upon their local laws. So, data controller must be able to demonstrate reasonable efforts in obtaining parental consent in such cases. The two factors that take into consideration while demonstrating reasonable efforts in the GDPR are the inherent risk and the available technology. You have to demonstrate this key when consent was not taken of the children's, then what was the inherent risk and what was the issues in the technology. um, the cross-border data flows in see the evaluation of DPDP bill is from positive to negative list. You know, when the earlier bill, rather when it was called PDPA, Personal Data Protection Act, it was we were having positive list like to whom the data can flow, which countries data can be flow, the list has to be maintained. But when you look at now, it says that any country the data can go unless and until data protection board or the government specifies that this countries the government these countries to these countries the data cannot flow. So the DPDP bill suggests using a positive list that would allow data transfer from India to selected countries. However, when the bill was near completion, it was revised to include negative list. And as I know the happenings, I think it was almost in last few days this negative list was added. So this means the act would specify specific countries that are prohibited from receiving data transfers. But while looking at the GDPR, GDPR allows the transfer of personal data outside European Economic Area, and if recipient countries offer sufficient safeguarding for personal data, this can be evaluated by the European Commission or through standard contractual clauses, binding corporate rules certified by data protection authorities, or explicit individual consent. So it is very clearly mentioned in GDPR. But when it comes to data principal rights under DPDPA, DPDPA outlines certain rights and duties for data principals. Now these are not punishable under GDPR, but they are punishable, or at least fine can be levied on data principles, because if the law has given you rights, the law also expects you to have certain duties. uh, the rights include the right to access information, right to correction and erasure, right of grievance redressal, and right to nominate. I would like to emphasis here that right to nominate is a right specific to DPDPA. This right to nominate right is not present in GDPR. So that is the difference, completely a different point of a new right come out of DPDPA. So while duties to data principals include to comply with provisions of the Act while exercising rights, to not impersonate any other individuals, to not withhold information while providing personal information for documents, to not make false or frivolous complaints, and to only provide verifiable, authentic information which while exercising the right to correction or erasure. So it's not a free for all big compliance exercise. It should be for the people following, or the organizations following DPDPA. So there are duties to data principals also. Now, when it comes to DSR or data subject rights under GDPR, the data subject rights mentioned in GDPR include the right to transparent communication and information, right to access, right to rectification, right to erasure, that is obviously right to be forgotten, right restriction of processing, right to data portability, right to object, and right to not be subject to automated decision making. Now, this automated decision making is a debated point still in DPDPA. Retention of data in DPDPA is different and GDPR is different. Now, how they are differing is, according to DPDPA, the duration for retaining data is dependent on the user's activity on the service. If the user doesn't use the service or exercise its rights for a specific period of time, the purpose for which the data was collected would be considered fulfilled. So please note, this is an automatic way of non-retention of data. The duration of retention would be specified by the rules that accompany the Act's provision. So this about retention, detailed retention period are written in the data protection rules. The retention of data in GDPR. Now, all data controllers are obligated by the GDPR to retain data solely for the period required to fulfill the purpose for which it was obtained. The GDPR specifically permits data controllers to determine the duration of retention. See, the power is there with the data controllers even. The data controllers actually should now regularly review and access their retention policies to ensure that they are in compliance with the GDPR, and the retention period is necessary to fulfill the purpose for which the data was obtained. If the purpose no longer exists, then the data should be securely and permanently deleted. Now, this is called purpose limitation in GDPR. Further, you can really read this in detail. Now, when you look at fines and penalties in DPDPA, here there is a huge difference, but then you will have to look this in Indian context. Now, the fines set forth by the DPDPA include, if you don't follow reasonable security measures to prevent data breach, that means you should follow reasonable security practices. The fine may extend up to 250 CR, 250 Indian rupees, 250 crores. Now, if you don't notify data protection board about or the data principal in event of data breach, the fine is up to 200 crores. Uh, Non-compliance with additional obligation with respect to processing children data, it may extend to 200 crores. Just imagine that you don't follow a data reasonable security measures to protect the data first, then you don't inform that the data was breached, and then the data is of children. Just imagine, you can calculate the amount of fine which could be levied on your company, because then you have to add the above, and it depends completely upon the data protection board to levy fine on you. It would depend completely on the type of data, type of company, amount of deterrence the data protection wants to bring in amongst the company which under breach and other companies of the same time. So, but when you look at GDPR, in GDPR, the fines are as very simple. Like according to Article 83.5, the fine may extend up to 20 million euros or 4% of preceding year's global turnover, whichever is higher. And while in Article 83.4 mandates a fine that may extend up to 10 million euros or 2% of the preceding year's global turnover, whichever is higher. Now, friends, let me tell you, now there are case laws available for the different fines which are being levied by different participating countries of the EU, by their different data controllers, which they have, data supervisory authorities they have, and these are easily accessible in a various supervisory authorities website. You can actually read, and these type of cases can actually also help you in determining type of legislation and type of cases which could be fought in Indian courts. Friends, we need to wait for the case laws to happen, various cases to emerge, and then the law will get mature. Now it is a completely an immature law, but friends, let me tell you, the best part is it is a smaller law. It's not that complicated. It's made up of 30 sections and few rules will follow. So, good luck in studying, and any questions, this presentation would be accessible in some or other social media platform. So, you can download from there for your further studying. Anything you need, my contacts are there on your screen. Thank you for listening to me on this short presentation. This is Advocate Dr. Prashant Mali signing off.